speaking with me, Tarun Nangia. Today, we're going to discuss an issue which is a subject matter of discussion across boardrooms of promoters all across India, general counsels all across India, promoters looking to invest in India, investment bankers, people who sit on plans in New York and London and Australia, look at India as a market, look to invest in India. That is about the enforcement of arbitral awards. And this is very important for any country that aims to grow at 7, 8, 9, and 10%, that there is certainty that arbitral awards should be enforced. How are the courts looking at the arbitral awards? What happens when these are challenged in the court of law after the arbitral award has been, in a sense, sees the light of the day? Now, I'm not an expert. I have some of the best people who can speak on this topic today with me on this two-part series that we record. Let me welcome Justice Arjun Kumar Sikri. He's considered to be one of India's busiest arbitrators. Difficult to get his time. We managed to convince him. Thank you so much for joining us today on this series. We look forward to your inputs. But I must also say, sir has served as, and now he's a sitting judge at the Singapore International Commercial Court. Earlier, he served as a judge of the Supreme Court of India. Thank you so much, sir, for giving your time. I have with me Sanjeev Gemawat, who's one of India's most renowned general counsels. Now he's the group general counsel for the Vedanta Group, which is a group headquartered in London, one of the largest business groups of the world, I must say, in the metals and mining sector. Also, for the first time, it has been created where there is a unified command for all the group companies. It surely rests well on Mr. Gemawat's shoulders. Good to see you, Mr. Gemawat, and looking forward to some interesting insights. You're known to be very frank as usual, and we appreciate your frankness whenever you speak. I have with me Sarosh Zaiwala. He earned a name for himself, migrated to London more than 45 years ago, one of the first Indians to start a law firm there, and who has grown his law firm over the years by leaps and bounds, handled some of the most high-profile cases also in India, worked a lot in India with PSUs also, and has earned a name for himself in the field of arbitration. Good to see you, Mr. Zaiwala. He joins us from London today, and looking for some interesting insights from you as well. I have with me senior advocate Percival Bilimoria. He practices at the Delhi High Court and the Supreme Court of India, worked with some of the top law firms in India before going into counsel practice. Now is one of our very, very busy lawyers doing top commercial cases. Also a lot of financial crime cases Mr. Bilimoria does. And in his, in a sense, in his former life, he was a chartered accountant, which I think the knowledge of mathematics helps a lot when you decode legal cases. Good to see you, Mr. Bilimoria. Looking for some interesting insights from you. I have with me somebody who represents a law firm that does like one of the busiest law firms at the Supreme Court of India, that is Karanjawala and Company, and Taira Karanjawala from that law firm joins us. She takes care of the Supreme Court practice there. Look forward to see insights, interesting insights from you, because a lot of these arbitral awards end up in the Supreme Court when they are not being, when they are not able to, parties are not able to enforce, and they are very closely watched as well. At the outset, let me request Justice Arjun Kumar Sikri that in the first 5 minutes, if you can make your initial comments, then we can move forward. Over to you, sir.
Okay, thank you, Tarun. And I'll take 5 minutes for making only initial comments or introductory remarks, as you can say. This arbitration, no doubt it is known to everybody that it is a method of alternate dispute resolution, deciding the disputes outside the court through arbitration. And there are many advantages of that. There are some, shortcomings of this arbitration process also. We are not going into that. But having said that, it is outside the court system, in the sense that there's a party autonomy, and the parties choose their arbitrators, or the arbitral tribunal is constituted, which decides the dispute. But it still remains a hybrid system, in the sense that we need the help of the court in any case. At various stages, from the constitution of the arbitral tribunal also, if it is not an institutional arbitration, application is filed under Section 11, and the court appoints the arbitrator or arbitral tribunal. And in between also there are, there may be interventions and support, if I may say so. If suppose witnesses are to be summoned, we have again to go back to the court for getting that order, that particular witness should appear before the tribunal. But the most important thing is that the arbitral award, which is passed by the arbitral tribunal, that under the new Act, 1996 Act, it is now a decree of the court, unlike 1940 Act, where award did not have any sanctity till it is made the rule of the court. It becomes a decree, but then again for execution of the decree, you have to go to the court. So therefore, in that sense, I say it's a hybrid system. And then it's not only for execution, but which we call enforcement, but then there is a challenge available through the medium of the court. A aggrieved party can challenge the validity or veracity of the award also, though on very limited grounds, which are mentioned in Section 34 of the Act. So therefore, the enforcement of the awards, since that is a topic which we are discussing today, and that's the theme of today's our panel discussion. So the role of the court becomes predominant. It is the court only which will be in a position to enforce the award, even if it is given by the arbitral tribunal. So therefore, now question is whether this court is playing its role appropriately in that sense, as well as enforcement, or what are the issues which are faced with. That is what we are going to discuss. Let me tell you one anecdote here. I mean, what is the approach of the court that is required? And you see, it was in 2006 or 2007, I think, our team of few arbitration lawyers with some judges of the High Court and Supreme Court, we had gone to Singapore. And so there was, it was at the invitation of Singapore International Arbitration Center, SIAC. And in that, there were, we were there were some persons from Singapore also. There was the CEO of the SIAC. There was one judge of the Singapore Supreme Court as well. And so we were there, the 3 persons from Singapore, 3 persons from our side who were on the stage, and we were discussing. And 2007 is the era when we were grappling with the saw pipe judgment and other, the Bhatia International, where these 2 judgments had come under much attack. And therefore, first we were asked to speak, and we said about our Arbitration Act, what are the difficulties we are facing, particularly in spite of these judgments, how we are trying to get through it and all that. But what I'm trying to insist or emphasize is when the turn came of our counterparts, the Singapore, the Attorney General was there. Attorney General representing lawyers, CEO of SIAC, that institution, arbitral institution, and the judge of Supreme Court. They spoke only one thing in one voice. That was the motto. We are the best. We have much better environment, not only for doing arbitral cases, but more importantly, here I am coming, that the courts are arbitration friendly. Once the arbitral award is passed, we don't delay, and we interfere in very rare cases. So the court is here to support the arbitral system or the arbitral. So that is what the approach is required, if I may say so. And the question is, when we go into this and we come to the nuances and nitty-gritties of the problems which are faced when it comes to the enforcement of the arbitration. But I would only say one thing here in my introductory remarks, that yes, initially when this act was passed, immediately thereafter, the Supreme Court, I still remember just, Sundaram Finance, judgment of Justice Kirpal, where he emphasized the need of, or rather the philosophy of the new Arbitration Act compared with the old Act of 1940, and then said that, look, we are here for enforcement. But then things changed after ONGC saw pipe, where it was perceived the way public policy of India, which is one of the grounds on which the arbitral award can be challenged, that if it is contrary to particularly international award, contrary to public policy, but it is contained in section 34 also, so domestic award as well. So very wide interpretation was given. And the way more important thing is the way it was interpreted, it led to the consequence that in every case, when it comes to the court for enforcement and when the award is challenged, as if the court has to go into the merits of the case, because issues are that said that if it is contrary to the contract, award is given, it is against that will also be against public policy. If it is contrary to law, it will be against public policy. But and therefore these some of these statements in that judgment was interpreted in such a manner. And I remember at that time I was in the High Court judges, that the petition under section 34 will be drafted in such a manner, and these would be taken, and ONGC saw pipe would be shown to us, and therefore we have to go into all that rigor as if we are sitting as an appellate court, which is not the function. Things changed thereafter, no doubt. And things again, I say that in introductory remarks, I'm only saying this much. If we go to historical background from 1996 till today, how the Arbitration and Conciliation Act 1996, particularly relating to enforcement, what is the history of that? So there are ups and downs. But then it was realized that it may not be good for the country, particularly because of these reasons. Insofar as domestic arbitration are concerned, there is no choice. These have to be here. But we are losing on international arbitration, and these are not coming here. The people want, after the award is given by the arbitral tribunal, that it should be enforced quickly. And they want a proper environment in that sense. So therefore, in order to tackle this problem, there was some legislative amendment in 2015 and 2019. We will discuss about that. Then apart from that, judicial pronouncements, which are given in last 10 years. And if I may say so, it all started with this matter in that sale case, that Constitution Bench judgment, which overruled Bhartiya International. And from that, and good thing is that the environment in the High Court, judicial environment is now in India very conducive. And the courts have interfered in very, very matters. But only thing, I'll stop there. But only thing, problem which remains and which we are still grappling is the delays. Yeah. So therefore, it should not be that the award is given and it still takes so much time when the petition under section 34 and then 37 and then SLP in the Supreme Court, by the time the award becomes final or the decree attains finality and goes for this thing, enforcement. So that is a problem. Yes, as I said, many amendments are made in the act, which are quite, which have created a conducive environment, and these judgments also. That is what my initial statement.
Thank you for those opening comment, giving a detailed, in a sense, introduction, but you give us hope when you say that enforcement happens, but time taken is something that should be catered to. And I'll take that to Sanjeev Gewawat. He is the Group General Counsel of Vedanta. Now, you represent, in a sense, a company in that sense, where you're headquartered in London, investing into India. But today, if you speak to me not as somebody from a company, but as a general representative of the General Counsels of India, what is the feeling of GCs across India? Because there's a body which you head, which is the General Counsel Association. If you can speak on behalf of the GCs here, what do they want? What certainty do they want from enforcing arbitral awards from the court system and from the arbitral system in India?
So, Tarun, first, thank you very much for having me here. I think it's a very relevant topic, and for multiple reasons. And one major reason is that Indian industry cannot afford to have a situation or system where we don't have the credible justice delivery system. It's not possible. If we are targeting a $5 trillion economy, $10 trillion economy, this is not possible without transfer of technology, without investment from outside India. And all these transactions would be needing cross-border transactions or even the domestic transactions. And all said and done, all transactions ultimately lead to one or the other issues, which leads into disputes. So you need a credible justice delivery system. The fact remains that with nearly 4.6 crores kind of cases, our justice delivery system through litigation perhaps not possible. We do not have any option. We need to have alternative dispute resolution only. That is the only option. I completely agree with the views of Justice Sikri on multiple issues. When he says that it's a hybrid system, it's very true. Just appreciate, Tarun, this fact that in this alternative dispute resolution, the way in which I see is arbitration is just a precursor to litigation. There are 3 stages on this. One stage is the pre-award stage. As Justice Sikri also pointed out that in Section 11, you will be moving for the appointment of arbitrator, or Section 9 in terms of interim relief, etc. So it's a pre-award stage. And then there is a post-award stage. And third is the enforcement stage. Out of these 3 stages, pre-award stage is the only stage where judicial interference or intervention or innovation is perhaps limited. But then as far as post-award stage or enforcement stage is concerned, it's nothing but litigation. It's nothing it's just judicial intervention and judicial innovation. Now, there lies the problem, Tarun, and in my initial comments, I can deliberate further on this. There are today, if I say I have a mixed response as a general counsel community, I say that today we have evolved a legislation. We have very good judgments in the recent past. There's no doubt about it. Last 2 decades, there's a lot of awareness, lot of training, lot of development and evolution as far as jurisprudence is concerned. But still, as Justice Sikri rightly pointed out, delay is the reason. Arbitration is cost effective and delay. That is the 2 major parameters, if speedy and the cost effective. Now, these are the 2 parameters, but then we are not achieving these 2 parameters for multiple reasons. And I am now focusing mainly on the enforcement of award, which is your subject matter today. Why we see these challenges in enforcement of award? For majorly 2 reasons. One is because of the judicial innovation and interference and interference at multiple stages, because parties would certainly take advantage of a situation where there is absolute unpredictability and uncertainty, where in a situation where applications get entertained in the name of social justice and public interest, which leads to invocation of the equity principles, you will end up having serious issues where commercial prudence, commercial contract, the terms of the contracts, they are just discarded in the name of social justice and public interest. Now, there lies the problem where both the parties, and I don't say that it's only the delays on account of our justice delivery system, that the one parameter of this triangle, but then even from a corporate side also, people will certainly take advantage, because if experimentation or exploration can give them some commercial advantage, why not? A party who is losing a case, he would be experimenting in multiple ways, because party believes that there is a lot of uncertainty and unpredictability as far as the final outcome is concerned. Now, so basically the cost benefit parameters would be determining the next course of action and the way forward. So I think, I would be resting my comments, because from a 5 minutes standpoint, that there are issues, despite the fact of the independence of judiciary, despite the fact that we have evolved jurisprudence today, we are facing problems, and I think we need to do something about it. Having said so, the last final comment is that we are still better off. We are still better off, even at the post-award stage and enforcement stage. We are not facing those difficulties which normally we face from civil courts, and from a litigation standpoint. We are still better off. We are not worse off. But still, there is a lot of scope in terms of improvements. That's it.
Thank you, Mr. Gemawat, for that opening comment. And speaking on behalf of the general counsel community, they are equal stakeholders in this whole judicial system, and you rightly put forward their views. I'll go to Sarosh Zaiwala, who joins us from the City of London. He runs a law firm there. Mr. Zaiwala, can you give us the international worldview on this issue when you look at India as a market and we look at enforcement of arbitral awards here?
I think so. Thank you very much for inviting me, and thanks to Mr. Hemawat and Justice Sikri for their very useful comments. I'm going to give a very frank opinion about my experience of handling arbitration both in India and England. I think the most important thing is the role of the judiciary. And the Indian judiciary, with respect, might need to change its view to cut short any application challenging the award unless there is interest of justice requires to intervene. And if the interest of justice requires to intervene, the court must find a way to intervene. This is what happens in England. It's very difficult to challenge an arbitration award. You have a right to appeal, but leave to appeal is normally never given, only in rare cases. When you challenge the award, there must be good grounds. And there must be justice because the innocent party must not suffer because of lack of cost or anything like that. I'll just give you 3 examples of 3 classic Indian cases before the English court, very important cases where my firm was involved. And the first was many years ago when I started my firm called the Steel Authority of India, SAIL versus Hind Metals. And this was an arbitration where the chairman was Mr. Lauterbach QC at that time, who was also a professor at the Cambridge University, a very eminent jurist. And Ashok Sen was a counsel appearing for Mr. Sen. And there were, for some reason, there were transcripts kept from the hearing because it was the Indian government matter. And there was unpleasantness between Mr. Sen and Mr. Lauterbach. And that was quite clear in the transcript. So there was an award of about $21 million in favor of the American company Hind Metal, and the award was challenged. And one of the ground was that there was a misconduct of the proceedings because the arbitrator did not behave himself. And it was just a personality conflict. And the judge, Mr. Justice Hobhouse, refused to enforce the above. And he said this in his judgment, which is reported in 1984, Lloyd's 414. However, the function of any tribunal, including an arbitration tribunal, is to separate the wheat from the chaff and to endeavor to arrive at a fair and just conclusion, notwithstanding the lack of assistance they may be receiving for the parties, one or more parties' representatives. And he went on to say, I would have been prepared to have held that there was a misconduct by the arbitrators in publishing the award they did. So this was one of the unusual cases where we had eminent counsel. But can I make, with due respect to India, what happens very often, that the Indian counsels are very aggressive, whereas in London, the counsel are very polite, courteous, and to the point. Even in the court, if you say, repeat a sentence, the judge will similarly say, look, I've heard this. What are you? You think that I've not understood it? So this is the first case, which is a reported judgment. The second very important case, which I think the court must keep in mind, that the judge's duty is to ensure, irrespective of what the counsel are saying, that the justice is done. And that is, law is for justice and not justice for law. And that is why London became the center. And I'm sure Singapore is following the same thing. This was another case which was not in a too distant past, but it was in 1990. Indian Oil Corporation versus Coastal Bermuda. Now, this was also for a very eminent tribunal of Gordon Pollock, and the chairman was, I forgot the name of the chairman, and Martin Mobic was later on became a Lord Chief Justice. Now, see the honesty of the arbitrator. Gordon Pollock, as you probably know, used to be, late Mr. Pollock used to be the head of Essex Court Chamber, a maritime chamber, is a very eminent counsel. And the award went against Indian Oil. Against it was about $16 million award. But Gordon Pollock wrote a postscript in the interest of justice, and he said the following: I wish to record my regret that the seller had not some stage broadened the scope of the case along the lines touched in the paragraph 9 above. Now, although opportunities were afforded to the sellers to consider whether defense might be formulated in any other possible less restricted way, the counsel refused to amend. And the result, I believe, is that the seller had a far stronger case than they had allowed themselves to advance, one which might have valid advances. However, the seller's learned counsel resolutely expressly eschewed any departure from the seller's case. In other words, what the arbitrator in a postscript said, very unusual, that the seller's counsel, Indian Oil Counsel, was incompetent. And had he been more competent, the result might well have been different. Now, parties had agreed not to challenge the award. And still, the award was challenged. And the Mr. Justice Evans, who later on became Lord Justice Evans, finally gave a judgment, which was a classic judgment, where he said, finality is good, but justice is better. So he refused to set aside, he refused to enforce the award. And in fact, Michael Beloff, QC, the eminent counsel, arbitration counsel, who is now in his 80s, he wrote his autobiography in which he mentions this quote, where the English judges have always focused on justice is better. I'll give you the other case, which was most recently, when one side we had expert evidence on Indian law, Soli Sorabji, and the other side was Harish Salve. And this was again a case about an Indian government company. My firm was instructed This is a GAFTA trading. Parties that appeared in a GAFTA, advocates are not allowed, and parties that agreed not to appeal. The arbitration award was out, but the clients considered that the award was bad, and they challenged it on the ground that the arbitrators had no jurisdiction because the contract had not been signed. Contract was not signed under Indian law. And what we argued was that because the contract was entered into on the soil of India, although it was an English law contract and the English arbitration law, its formation would be under the Indian law. And we had the evidence of what is Indian law. And because this is a government company, and the government company has special rules as to who has the authority to sign the contract. And we had Solis Rabji giving evidence before Mr. Justice Andrew Smith and Hari Salve. And the court found on a technical ground that the award was not enforceable because although parties participated in the contract and there was also an appeal procedure, and the award is not enforceable. It's a classic judgment. I thought I'd just bring it to you. So what I would like to stress is that the confidence which the parties have in the judiciary, that matters a lot. So you can take points to challenge the award. The judges don't have a closed mind if there is injustice. Whereas I find very often, possibly unknowingly, the judges are a little technical. And if I may be blunt and say, with utmost respect, that as comparing it, it is possible that we are still living, our legal system is still partly under the colonial, how the British colonial system used to approach. Whereas in London, I find that the judges and the counsels are all down to earth practical. If I go before a judge and I make a point which I repeat it or which I not right, the judge will ask me, are you really serious to make this point? And I sit down. Whereas we allow our counsel to argue and continue on the basis that they have a freedom to speak. So I think that is where Mr. Justice Sir Sikri should really try and educate and sort of bring known that what we need is a practical approach. The commercial parties require a judicial decision which is fair and right and not lengthy arguments. And that is how today London is still the leading center of international arbitration. So thank you. I hope I have contributed. I just brought this to the attention because you have a right, one must have a right to challenge the award, but on a good ground and to the point on issues of real justice.
Thank you. Thank you for that intervention and the three examples that you gave, the three cases you cited. I'll go across to Senior Advocate Percival Bilimoria. Now, I know many times you take up international arbitrations, you also do domestic arbitrations. And I know how many times we have chatted about how when you have a cross for 5-6 days, you are busy, you don't pick up calls, you are completely into it. So you have an understanding of how both international arbitrations function, how their papering numbering functions. We've discussed so many aspects of arbitration with you. Could you bring forth all that expertise on your answer today on the show?
Yeah, thank you, Tarun. So I think Justice Sikri mentioned the amendments in 2015, which were quite a watershed bunch of amendments, and that has really changed the arbitration scenario in India. So, what I heard from Sanjeev and Sarosh, I need to just ask, which arbitration are you talking about? Because I completely disagree with what I've just heard. All right, I'm sorry, but this is completely removed from reality. Okay, today, I think there were spatterings of what when Sarosh said that, there was an English judge who said, finality is good, but justice is better, right? So Indian courts have in the past grappled with this notion of justice. Now, there are today 3 types of arbitrations. One is a purely domestic arbitration governed by Part 1 of the Act. Part 1 also contains what is known as international commercial arbitration, which is India seated, but the one or the other of the parties is foreign domicile. So you may have if you're talking about cross-border, for example, you may have a foreign investor or someone who provides technology and having a dispute with the Indian party. That comes under international commercial arbitration. And the third arbitration is foreign seated, where there's an arbitration award made outside India, which is sought to be enforced here. See, if you see, there are 2 provisions for enforcement, 34, which applies to Part 1, and 48. Now, the history that Justice Sikri recalled is the whole controversy about what is meant by public policy. Now, there was one English judge, Justice Burroughs, who very famously said that public policy is an unruly horse. Indian courts have debated this issue. We have now come down to, so ONGC versus saw pipes is no longer relevant when you come to international commercial arbitration or when you come to foreign seated arbitration, because the law has been amended to provide that any challenge on patent illegality, which was what ONGC versus saw pipes is all about, any challenge on patent illegality will apply only to domestic arbitrations under Section 34 of the Act. So again, when you talk about finality and justice, I would like to ask Sanjeev that, when you are deciding to make an arbitration clause in an agreement, do you opt for ad hoc arbitration? Do you opt for arbitration according to institutions? Because remember, institutional arbitration is a completely different cup of tea. In India, unfortunately, ad hoc arbitration still rules the roost, and that has been part of the problem. The 2019 amendment, Justice Sai Krishna's report tried to deal with that. The difficulty in this country is that, of course, we have many arbitral institutions, some of that very, very good. But, when you take the example of SIAC or LCIA, they have a great panel of arbitrators. They also have peer review of awards. So you are assured of one thing, which is that what is the probability of an arbitral award being unfair or not in accordance with the contract, the letter of the contract. I mean, the probability of getting the wrong end of the stick in such an arbitration is very low. So you can talk about enforcement in those cases, speedy enforcement, right? But when you come to ad hoc arbitration, I mean, see, look, any large Indian corporation, I believe, despite these changes, will not adopt purely Indian seated ad hoc arbitration. Why is that the case? Because they are assured of a proper award in the first instance, because remember, you only have one bite at the cherry. If you're going to challenge that award, rightly so, because that is the whole philosophy of arbitration, because it is a private consensual process. But if you're going to have one bite at the cherry, then how about ensuring that the probability of getting the wrong end of the stick in that situation is very low? And you can only do that with proper institutional arbitration. So when you come to enforcement, please understand that anything on patent illegality, which is what saw pipes is all about, applies only to purely Indian domestic arbitration. It does not apply to international commercial arbitration or foreign seated arbitration. There is also another fundamental difference. When you talk about foreign seated arbitration, you have a foreign award. Now, the foreign award is sought to be enforced against an Indian party, because if the Indian party is arbitrating outside India, and then the Indian party has assets in India, then there is a question of enforcing that award, which is materially different from the Section 34 provision, because there you're looking at you're challenging the award itself. You're not looking at whether it can be enforced in India or not. So these are very nuanced situations. I disagree with the proposition that Indian courts. In fact, I feel that now, after the 2015 amendments, the pendulum has really swung the other way. Today, Indian courts will not entertain any long arguments. Of course, like Sarosh rightly said, Indian counsels are very innovative and aggressive. So, I have a live situation where, so Supreme Court has decided that, look, the challenge proceedings are summary proceedings. Now, I have a situation where the opposite counsel said that, okay, this is a summary proceeding. You can't have such a long Section 34. Right, but I said, but look at FISA developers. I mean, FISA developers even allows for evidence in certain situations, because ultimately the party should be able to make its case. There is nothing in there to say that it should just be a very brief 2-3 page Section 34 submission. summary proceeding doesn't mean that it is to be in a summarized form. But there is somebody who's taking that argument against me today, right? So this is the innovation of Indian lawyers, and he's getting away with it. He won't for long. But the point is that wastes a lot of time. So the point is there are a lot of sharp elbows as well in India. We have to take all this into account.
Thanks for your opening comment, Mr. Billy Moria. I'll now take this to Tahira Karanjawala from Karanjawala and Company. Tahira, your opening comment on the enforcement of arbitral awards.
Thank you so much, Tarun. Tarun, I just, in fact, want to try and sort of address both the schools of thought that have already been expressed on the show. So I think actually, I tend to agree slightly with Mr. Bilamoria that after the 2015 amendments, there's been a legislative as well as a judicial push towards a more pro-enforcement attitude towards arbitral awards. So the 2015 amendment itself firstly had done away with the concept of an automatic stay when you file a Section 34 challenge to an arbitral award. Earlier, that was the case. After the 2015 amendments, now you have to move a specific application for stay of an award, and the court can, and often does, order deposit of the awards and withdrawal subject to bank guarantee, etc. So that's one sort of automatic protection that has been brought in by the legislative process. The second set of important amendments to Section 34 have also clarified the scope of the challenges that can be mounted. And of course, these are very limited, and they are sort of mirrored in when a foreign award gets challenged in India, they are sort of mirrored in our Section 48. And these are very limited insofar as, if one of the parties was under some incapacity, if the arbitration agreement itself was not valid, if the subject matter is not arbitrable, or if the award is against the public policy of India, which has been now narrowly statutorily defined to mean either that the award has been induced by corruption or fraud, or it's against the fundamental policies of India, or against the basic, notions of morality and justice. And in fact, even judicially, there has been a number of judgments where the Supreme Court has recently, especially after 2020, held that any objections to the enforcement of a foreign award specifically have to be very narrowly construed. For example, in the case of Vijay Karya, it was held that even an award which entails a non-compliance of FEMA regulations is not an award that can be refused enforcement. In fact, there was a case of Gemini transcription where the court has made it explicitly clear that the enforcing court here cannot get into an adjudication of whether the award was correctly decided under the law to which it was subject. In that case, it was the Delaware law, or that the arbitral tribunal in that particular case gave a sort of guesswork as far as awarding damages is concerned. They have clearly and explicitly said that those are within the realms of the arbitral tribunal, and at an enforcement stage, we will not get into it. There was a controversial judgment in the NAFAD case where they took a different view and held that where an award, enforcement of an award would have amounted to a violation of the export policy. In that case, enforcement was refused. But overall, what I find, and from my limited, and my experience is much more limited than any of my other co-panelists, I find that in the last few years, whether it is legislative or whether it is judicial, there has been a push towards having a pro-enforcement attitude even in India. I think where Mr. Gimawat and Justice Sikri, I completely agree with, is when they say that it is actually the inherent delays of our judicial system which caused the problem. It is not so much either the law or the judicial precedent. It is actually the day-to-day when you go and actually enforce the award. And as Mr. Bilamoria said, every counsel will take innovative arguments. We will all, if we are opposing enforcement of the award and you really know that there is no ground to oppose that enforcement, you will try and delay the matter as much as possible. So these are and it is perhaps the lack of strictness, that we all take advantage of, which creates the systemic problems which we probably face, not so much in the theoretical law, but in the practical application of it. That's my views.
Thank you for that opening comment. But coming to what Justice Sikri said, and if you see even the Delhi High Court and the Supreme Court, there is no interference with the awards as a very pro-arbitration attitude in Delhi High Court, at least we see always. And there's so many arbitrations which arbitral awards I can cite. Enforcement sometimes is a bit of an issue. 2 cases in point for the Antrix Devas case, which is the award is taking time for enforcement. There's a Delhi Airport Metro Express Limited versus DMRC, where partial enforcement has happened. Despite a Supreme Court order, the enforcement hasn't happened. That is worrying. So, what message that sends to the investors? Because if we at least speak for the case of DAMEPL, which is a Delhi Airport Metro Express Private Limited versus DMRC, if it can't be enforced, then will in future contractors build in this risk when they bid for contracts? That if we win an arbitration against the state can change the rule or make it difficult to comply with. These are some of the concerns, but largely, of course, the courts have had in a sense, encouraging attitude towards arbitrations. But the worry remains for the promoters is that when the other party is the government of India, is it more difficult to enforce the contract? That I'll leave open. We'll go to the next round of interventions. We'll request Justice Arjun Kumar Sikri for his second intervention on this issue. Over to you, sir.
Yeah. Thank you, Tarun, again. And if I may say so, this first round was really interesting, and 2 views which emerged. I should say one thing. I started with this, which was echoed by Percy as well as Tahira, that in last 10 years, the environment has changed. It is pro-arbitration, legislatively also, and judicial approach also is towards that end. And the problem is only of delay, which is mentioned by them as well. And Sanjeev, of course, agreed to this to great extent, but flagged some other issues in the process of enforcement, etc. Now, coming to what Mr. Zariwala said, and there I will agree with what Mr. Billy Moria has remarked. Now, let me tell you one thing, and that is the main bone of contention insofar as judicial approach is concerned. Mr. Zariwala said that I would say very highly qualified or such a good expression used by the judge that finality is good, but it is ultimately justice that matters. This is a statement which has been quoted many times. I've seen many articles, etc., but has been criticized also. It's not appreciated, but criticized when it comes to arbitration. And that is and Mustil in his book has also written. And when the first edition of, I think, Mr. O.P. Malhotra, Andrew Malhotra's book on arbitration came, she was a lawyer at that. Now she has written other, editions as judge of the Supreme Court. But there also in his foreword, Mustil has said that this tendency of the judges or judicial approach that we have to do justice. Now, the moment you have this approach that, okay, whether justice is done in this matter, finality may be there, but whether justice is done, the moment we start looking into the matter as far as arbitral award is concerned from that angle, then we become appellate court. We go to the merits and find out whether the outcome is justified or not other way. And that is what a very interesting situation. This was the approach in saw pipe of the Indian Supreme Court, was criticized globally. And it was said that, look, this should not be the approach, and which led for almost 10, 12 years, insofar as Indian judicial system is concerned, or the approach towards enforcement of arbitral award is concerned, or challenge to arbitral awards is concerned, it was criticized till the time then the legislature had to intervene in 2015 amendment and then 2019, and judicial approach also started changing from, as I said, from 2014 onward. And thing is, the other view is, which is equally good or rather better, I would say, that the parties, party autonomy is there. Parties have chosen their arbitrators, correct? They have chosen their tribunal. So therefore, we can't go into the nicety or legalities, etc. It is also a principle of law, or rather, when you, examine the award of a court, when the court examines the award of an arbitral tribunal, that whatever the on the basis of facts on record, whatever findings are given by the arbitral tribunal, they are final. Courts are not going to. Even interpretation of the contractual provisions given one way or the other is final between the parties. Court may, after examining the same provision, may come to different conclusion insofar as the interpretation is concerned, but that is no ground to interfere. That is the law on one side, which is now Supreme Court, and as you rightly mentioned, Delhi High Court. It's not only Delhi High Court. Yeah, Delhi High Court is pioneer. I'm in love with Delhi High Court, and I would say that they are doing yeoman job. But then I would not, leave behind Bombay High Court and Karnataka High Court and other high courts as well, who are doing really good job in this matter. And therefore, I would come to this, that the problem is today only of delays because of number of cases which are pending in. And this is also tried to be taken care of to some extent. As far as legislature is concerned, as Tahira rightly mentioned, even if finally it is not enforced, at least by interim measure, Section 36, where under the unamended section or provision, there was an automatic stay. Let me tell you, as Delhi High Court, in spite of that provision, I was little bold in interpretation. And in one of the judgment, I said that, look, it is ultimately, it should be read as analogous to Order 41 Rule 5. So court should have discretion whether stay should be given or not. Because my, approach was, or rather the purpose behind it was that, look, not that if the person who has taken the award should be rendered remediless or as far as enforcement is concerned till the time challenge to the award is settled. Anyway, going by the letter of the Section 36, I was overruled at that time, but at least legislature listened to me, and this amendment is done. Now, therefore, even if you don't get the fruits immediately, which has to be at the enforcement stage, and even at this challenge stage, at least you can get, as Tahira mentioned, the court can always pass an order that, look, deposit the amount, and that in many cases, partly or fully, that amount is even given to the award holder, subject to certain condition that you give some security, etc. So they are able to have the fruits. So that is one way of salvaging the position. Other way, which I would say is, which has been done by Delhi High Court again, and some other high courts also, of course, under the Commercial Courts Act, it is now throughout the India, but the commercial courts which are set up, and in Delhi particularly, even before setting up of the commercial courts, from the time of Justice A.P. Shah, I remember in 2008-9, in those days, a special benches to hear only these matters. Our arbitration court was set up, the bench was set up. So there should be such benches in all courts who should take care of these arbitral awards and enforcement of arbitral awards, so that they are on a fast track mode. So these are some of the aspects on the basis of which we can still push the things and make the things little better.
Thanks. So that, in a sense, encapsulated the approach of the courts, and also what you said about not only Delhi High Court, but also Bombay and Karnataka High Court and other high courts on the issue of arbitration. Also, your point where you said about non-interference and becoming an appellate court, very relevant in today's time. If that is the attitude, then no arbitration or ADR can succeed. And in fact, you said you love Delhi High Court. I think you were the ones who encouraged mediation greatly, both in Punjab, Haryana, as well as Chief Justice of Delhi High Court. That remains a contribution that we all cherish and celebrate. And the Bar also talks about it often. I'll go to Sarosh Zaiwala from Zaiwala and Company for his intervention.
I find these discussions very, very interesting and also very knowledgeable for me. When I talked about the interests of justice, what I really, these are exceptional cases. For example, the two cases which I mentioned, one is the Ashok Sen, a very eminent counsel himself, barrister, and where it was clear to because the transcript, it became clear to the judge that somehow or the other they had a personal conflict in the way they were approaching to each other, and therefore points were missed. The judge took his own initiative to say that the award is not enforceable, and he would have held it was a misconduct on the part of the arbitrators. Now, it's a very unusual situation, a rare situation. I brought it out because it's a rare situation. Also, in the Indian Oil case, where finality is good or justice is better, it was a very unusual, the integrity of the arbitrator who found that the counsel was incompetent, who was appearing for Indian Oil, and they were counsel from India. Whatever he found, he was English barrister, but of an Indian origin, and he went on his own, decided, and he own put a postscript that if the case had been put other way, or what he has suggested the counsel to put, the result would have been different. Now, in that case, the interest of justice, so the judge said, Mr. Justice Evans, and he was a very fair judge, Court of Appeals, became a Court of Appeals judge. He said finality, only in that context, he said finality is good, justice is better. Now, this brings confidence to the community to go for arbitration. But with humility recommend that what the Indian judges could do, very often the English judges do, when an award is challenged, in 80 to 90%, the judge shuts the counsel within 30 minutes. And he gives a no. Now, there's a new rule which has come in the English procedure. The witness statements or what used to be affidavit has not to be more than 10 pages. And you cannot argue law. And so that makes it easier and more sort of focus for people to do. So this is something which also the Indian legal system can also incorporate, because what the businessman wants is a quick judgment, quick enforcement of award, not long-standing arguments of innovative arguments. You can make an innovative argument to the court, but the judge will immediately say whether it's good or not. If it's not good, okay, sit down. And he will in his own way say, okay, I've listened enough. Now this is the time to stop, without being annoyed or upset about it, in a cool and calm manner. And I do think that India is today ready to become the fifth or the fourth largest economy in the world. And therefore, it's very important that we give confidence to the investors. There's going to be a lot of investment. And everybody says, oh, but in India, the cases drag on. It does not drag on in England. The same sort of situation happened, but the court makes sure that the counsels are strictly disciplined by the judges that not to cross the line and stay within the argument and not to repeat argument. And that is something which Mr. Justice Sikri could take a lead, even in the arbitration for it happen, so that we don't go round and round and round. And the most important thing is also when the applications are made to enforce the award, the judgments very often, I hear this, I don't have my own personal experience, but clients tell me that there are adjournments application for some ground or the other. Now, in the English court, if there's a hearing is there and if the counsel is not prepared, he's dismissed. Simple as that. He can appeal, he'll never get leave to appeal. Now, this is a discipline. In the beginning, it may seem harsh, but once it becomes a rule, we are all very, very careful not to upset the judges, not to upset the principal. And as a result, today, there's so many cases are still coming around from all over the world for arbitration. And I think the Indian mind and the Indian judiciary intellectually is very, very high. One knows about the famous judgments or famous judges. And similarly, the Indian lawyers are very, very good. But the system somehow or the other, when I say it's the old colonial system, I may be wrong, but I say with respect, we still follow the old of going strictly, giving everybody an opportunity to speak. You can cut the barrister down without being rude in a courteous manner with a joke. And this is very often with the judges in England, okay, I've heard this. Is there any new point that you have? And you automatically sit down and the case goes on. And the time schedule is very, very important. And unless India ensures that the foreign investor has a quick judicial remedy through a private arbitration, it can be held in India. It could be Indian arbitrators, there's no problem. But it must be quick and honest. And what the judges need to ensure that there is honesty and justice and there is no suggestion, because there's some suggestion sometimes of corruption coming. I don't believe that I've come across any issue of corruption among the judges or the arbitrators. But if there is any suggestion, it is dealt with quite strongly and immediately. Thank you.
Thank you. Thank you for that.
Sorry, I only would say, Mr. Zariwala, all these points which you have said, how we can improve the functioning of the court, they are well taken. They are really very good. Not only that, we are, because since you said that Justice Sikri can take care of that, so I'm responding. And steps are taken in that direction. There are many judges who are strict in these things, and they mean business. They would like to hear, will not give unnecessary adjournments, etc. And yeah, you are right. At the same time, adjournments become a matter of rule here many times rather than exception. And that phrase, this tariq pe tariq, sometimes that proves to be correct. And so therefore, these steps should be taken, no doubt about it. And I will only say one thing, Mr. I never said the 3 judgments which were given and which you quoted that the decision was wrong. It was excellent decision in the facts of all 3 cases. But many times the principle which is said, here the finality is good, but justice is better. So if every judge starts, no, I have to see justice is better in every circumstance, in every situation. So then that particular phrase or particular principle which is laid down, it is bound to be misused in many cases, depending upon the wisdom of a particular judge. That is what I wanted to say.
I agree with you. I agree with you, sir. But that is exactly the standard of judiciary and discretion of the judges which matters here. Not all judges would say that.
Exactly. I agree with you. Yeah.
Thank you for both the interventions. I'll go across to Sanjeev Gemawat for the second round of intervention.
Tarun, I'm missing your
Over
voice.
to you, Mr. Gemawat.
Yeah, no,
So I said I'm going to Mr. Sandeep Gemawat for his second round of intervention.
perfect. No, so Tarun, I think, look, as I said, that arbitration jurisprudence has evolved. We are in a better situation last 2 decades. It's a tremendous development in terms of not only from a legislative standpoint, but then from a precedent standpoint also. And today, I agree with this fact that today, courts and some of the courts in India, particularly Delhi High Court, Mumbai High Court, they are very, particular about, enforcement of awards and, not entertaining frivolous applications and all that. So it's all reality. This is happening. And I said that we are in an evolved kind of atmosphere. But having said that, let's not also ignore the reality. Today also, we are still 164th as far as enforcement of contract is concerned. And so let's accept this reality and let's work towards this in terms of what improvements we can bring. One fundamental issue is, and I think Percy mentioned about that institutional arbitration or ad hoc arbitration, and I think that it's a very important and relevant issue. Traditionally in India, and particularly as far as the domestic arbitrations are concerned, they are ad hoc arbitrations. And those ad hoc arbitrations are largely dominated by the retired judges. Now, these retired judges are coming from a certain amount of certain kind of discipline, where, and where in the last many decades, the social justice has always been the backdrop in which the decisions have been imparted. And so invariably, you will find that when the arbitral award is given, at times, particularly in ad hoc arbitration, I'm saying that while the equity is not conferred under law, but then the arbitral awards are given based on equity. Now, there is a challenge. And then that's exactly the reason why I say that in the post-award stage or even in the enforcement stage, you need at times court intervention, because somewhere there should be checks and balances. How would you be continuing a business if those checks and balances are not there? So this is important. But the difficulty here is, even in these checks and balances, at times frivolous applications get entertained. And these frivolous applications get entertained because who is the counterparty? That determines that. And believe me, Tarun, despite of the best of the judges, there are always situations and circumstances when an applications come to a judge. He will not ignore it as it is. He will have to at least give it a consideration. Now, in that process, the delays happen. I think this is one issue which is bothering the industry in terms of these kind of delays. Ultimately, nothing comes out. But then to that extent, the delays have already caused. Now, believe me, Tarun, and Percy asked me for the examples. Percy, I can give you examples there where for last 10, 12 years, Section 34s are pending. Still today. Section 34 is pending. If the counterparty is the state, all the more reasons. I have seen those examples, and Justice Sikri, you will certainly appreciate. A decree holder in the arbitral award, a foreign award, which has been settled from all the levels, from the original jurisdiction, it comes for enforcement, and in the enforcement court, the decree holder is paying the bank guarantee to the court. Now, is this not a mockery? Because the other party is the state. Now he has taken money, but then he's still giving a bank guarantee and enforcements are pending. Now we have these situations also. Now, somebody can very well say that these are exceptions, perhaps, yes, exceptions, but the fact remains that these are some exceptions create our image as far as the investor world is concerned. That is what we should be concerned about. And we should accept this reality somewhere that, yes, some correction needs to be done. I have, during some informal discussions, at times various suggestions come. For example, special courts to be given for these, enforcement of award and all that. Perhaps that might help, perhaps that might not help, because for the simple reason that wherever the special courts are there, we have some good experiences, as well as we have those bad experiences where even the stipulated timelines in the statutes, they have not been met. There are examples in whether that be IBC or any other law. So there are examples of this nature. Perhaps somewhere I feel that if the respective high courts develop some procedure whereby, as far as these post-award complications are concerned, whether Section 34 or the appeal under 37, etc., there should be some timelines. A self-created timelines in, say, 180 days, these should be resolved. Perhaps that would certainly help the industry in terms of giving at least one is the certainty and also the predictability of the award. I think this is what we should be doing in terms of suggestions. That's it.
Thank you, Mr. Gewad. Frank as usual, but you went straight to the points. These 2-3 points that you said are very relevant. We could take them up again also in upcoming shows. I think sometimes I joke that a lot of people are ears to what Justice Sikri says time and again. So some message from him always helps.
Yes.
People do follow with all the respect they have for him. So whenever I want something to get out, I request him to talk about it. But that we'll come to him for the final comment. I'll go to Mr. Percival Biliboria, senior advocate, for his comment of second round.
So actually, there is a statutory timeline in Section 34, but you're right, it's probably not always followed because it is taken to be directory and not mandatory, but there is a timeline. Look, my only point is that, we now have a very good, robust law. All right, so let's put aside the jargon. All right, let's see. Now, today, if you have a situation where the award is decided on an erroneous proposition of law or an erroneous application of law, or which is even against the terms of the contract, right? That is patent illegality. Now, that patent illegality is not applicable to international commercial arbitration or foreign seated arbitration, right? So these are only arguments that are left for purely domestic arbitration. So what I'm saying is that as far as international commercial arbitration and foreign seated arbitration, in fact, I can tell you that now Supreme Court also has been very aware of this problem, and they are disposing of enforcement of foreign awards very quickly, very rapidly compared to the past, right? The problem remains in purely domestic arbitration, and I'll be very honest with you, this is the reason why I first said that would you ever have purely domestic arbitration? You would not. And the reason for this is, to be very blunt, quite apart from the major industrial giants, there is a soft middle tier of Indian businessmen who opt for arbitration, thinking that, okay, I can appoint any arbitrator. So instead of appointing a respected jurist, he will appoint his brother-in-law. Now, even this has now been resolved because now you have Section 12 and 13. And in fact, Justice Sikri has authored a very important decision when Justice Sikri was in the Supreme Court, the Vost Alpine decision, that talks about how an arbitrator may have conflict, or in fact under 7th schedule is totally ineligible to act as arbitrator. So even that issue has now been taken care of. It is only the practices in purely domestic arbitration that are still lagging behind. One is we don't have transcripts. So, when you have a hearing after 6 weeks, the opposite side will argue that last time I said this, but look, you never said it, but there is no transcript, right? I have detailed notes, maybe the arbitrator has detailed note, but there's no transcript to establish that. So people can get away with these things. So there are certain issues that need to be looked at. Transcripts, lack of transcripts is one of them. There are 2-3 other practical issues that need to be looked at to bring Indian arbitration up to speed with foreign arbitration. And it can be done very easily, but I do not believe it needs too much fiddling or amendment with the law, because the more amendments that you do with the law, Indian lawyers are very innovative. They'll find their way around that. See, even just before the 2015 amendment, there was a decision, by the Supreme Court, which said that, well, Wednesbury principle should apply. Now, what is Wednesbury principle? Wednesbury principle means that if somebody has come to a decision which no reasonable person will ever come to, looking at the facts and circumstances. Now, if you are a litigator, you would say that, yeah, Wednesbury principle, it looks very reasonable, it should apply. So the Supreme Court said that it should apply when you're looking at a review of awards. But even that was struck down. The Law Commission inserted, 2 more provisions to say that in looking at challenge to award, there will be no re-looking at the merits of the argument. There will be no reappreciation of evidence. So our law now is very robust. It can be enforced, but we need to deal with the practices. It is the practices that have to be hauled up. That we have to pull up our socks on the practices. That is the only thing.
Exactly.
Thank you so much for that intervention, Mr. Bilimoria, where you raised some very important points. I will go across to Tahira Karanjawala from Karanjawala and Company for a second intervention.
Thank you, Tarun. Tarun, so I just want to highlight actually and expand on one of the points that Mr. Gemawat also had made in his second round, which is when there are arbitrations against the government. One of the major problems I think that contractors and often clients of ours face is that unfortunately, when you either litigate or arbitrate against the government, they are unwilling to settle disputes at all at any stage, because the concerned officers do not want to take the responsibility lest any sort of allegation is raised against them for having compromised the matter. And I think this is actually one of the major problems for all contractors across the board when they deal with the government, because you will have a situation where they will challenge you even at the Section 11 stage, even though today the law is very clear that if your managing director cannot be appointed the arbitrator in a dispute, or he cannot nominate anybody. However, this one still has to go to Section 11 court to get an arbitrator appointed. So there will be that leg of challenge. Then 34, so definitely there will be a challenge. There will be an enforcement stage challenge. So I think one of the things that apart from handling the delays of the court process, if the government at its end tries and implements, and I believe there is a scheme. The finance ministry had announced Vishwas scheme for settlement of disputes, where they propose to pay out 85% for court awards and 65% for arbitration awards as a one-time settlement. So I think steps like that from the government's end would also actually help to streamline the delays and help with quick settlement of disputes, because ultimately in this kind of situation, both the parties suffer. By both parties, I mean the contractor suffers because he doesn't get his money for years and years. And at the end of the day, even if he wins, there's a huge amount of interest that the government entity has to pay. So at the end of the day, the public also suffers because they're also paying an extremely high interest, which had the entire issue been settled at a preliminary stage, or at a not preliminary stage, but at a, sort of at the appropriate stage, this situation would not have occurred. So I feel like this is another step that can be taken apart from handling the court, sort of handling the court delays as much as possible.
Thank you, Tyra, for that intervention of yours. It was a very fruitful discussion today. For the final word, we'll go to Justice Sikri. And for your pearls of wisdom on this issue, the final word in about 2 minutes.
Yeah, let me sum up all what we have discussed. Is that insofar as our statutory scheme under the Arbitration Act is concerned, relating to, I'm limiting it to enforcement of the awards, this is today impeccable. Maybe I don't know whether some further statutory amendments are required or not on this aspect, notwithstanding the fact that few days ago only the government has appointed another committee of certain persons to go into the Arbitration and Conciliation Act and to suggest the amendment. So, but when it comes to enforcement of the award, whether any other amendment is still needed or not, just to clarify some of the more things more, that may be a different aspect. But what I feel is, by and large, our statutory scheme is well in place. Likewise, as we have been discussing, the judicial environment is also now, and our judiciary is very clear. That is, we are arbitration pro, and we are pro arbitration, and we are for the enforcement. And therefore, the problem is only as far as at present is concerned of the delays, which may be of various nature and because of various reasons. I mean, we are, as Sanjeev also said, that 4.6 crore cases are today pending. I mean, there are all types of cases in all courts, of course. But then when all these kinds of cases are to be conducted by the courts, it is not that the court can give that, okay, we have only arbitration cases and we'll first look into the cases of arbitration and other cases will be put on back burner. That situation cannot be there. Importance has to be given, or preference has to be given to many other types of cases as well. So therefore, the number of cases is one such problem when it comes to enforcement. And Sanjeev also said that there are matters where for 10 years, 12 years, Section 34 are pending. It is because of sheer volumes and the kind of discipline, judicial discipline, I will say not judicial, sorry, the court discipline, which is required in entertaining the cases, which Mr. Zariwala said, and what happens in English courts, and about adjournments and unnecessary lengthy arguments, etc. And the way we are not able to imbibe that. As I said, I agree. So those kinds of, that approach has to be different. Of course, we have the tendency, which again, speakers have said, that those and lawyers, there are all kinds of lawyers. And if award has gone against me or by my client, and I'll try to delay the enforcement and will adopt every kind of trick in which is available to me. But that is the challenge, is to then not to allow all those things. And the third thing which Tahira said, very rightly so, in most of these cases, particularly arbitration cases, maybe 65 or 70% cases, government is the party. Government here, I include public sector as well. And therefore, yes, government is coming out, the government should see. It is not that every case is to be challenged, award is to be challenged, and it is to be challenged, and the challenge has to be taken till Supreme Court. There may be situations, and obviously nobody is always happy with the outcome. It is not only an arbitral process. Even if it is a court, in the court itself, one judgment, and we keep on taking it in appeals, one is not satisfied. After Supreme Court, we don't take it, may still not be satisfied, but we know that now there is no further appeal. And this was the last court which has already decided. So therefore, the government also should come. And what I say that, yes, from this Vivad to Samvad and all that which they have said that we should, what is needed is walk the talk. That although these kinds of policies are framed by the governments from time to time, but in real practice, they are not implemented to that extent and with that zeal. There may be various reasons for that. And but then the challenge is to overcome those difficulties and reasons. And the court, the government should not be the litigant of this nature, that no, we have to take everything in appeal. So if some of these steps are taken, otherwise we should be able to, and I have been reading in various international journals also now, as far as the judgments of the Supreme Court are concerned, or even our high courts are concerned, they are praised a lot. But at the same time, when we come to investors, as again, I would say Sanjeev said on behalf of GCs or on behalf of the business world, they ultimately won't go into, okay, last product may be very good, outcome may be good, but when I'm going to get that outcome, that is more important. And in the process, how I manage my affairs,
Yes.
and what business wants. And that is the very purpose of arbitration. So if that has to be achieved, we have to send that signal. And these are some of the steps which are suggested by my co-panelist, which should be taken. I think we may go for better things.
Thank you so much for summing up this two-part series that we do. And one good thing that comes out is, I think whenever you say something, it is taken with a degree of seriousness, and we have seen decisions happening when you speak. So much goes to all the respect people have for you. Also, it comes with a positive approach to things. Thank you so much for being part of this two-part series. I would like to thank Justice Sikri, Sanjeev Gemawat, who represents the General Counsel Association, also serves as a Group GC of Vedanta. Zaiwala, Sarosh Zaiwala, founder, managing partner of Zaiwala & Company, joined us from London. Thank you so much. Senior Advocate Percival Billy Moria, who also does international arbitrations and domestic arbitrations. Some good points made. Thank you so much. Tahira Karanjawala from Karanjawala & Company, some nice interventions. Thank you all so very much. Looking forward to see you next month on our next two-part series on other issues on arbitration. But on enforcement, that's it for now. Appreciate your joining us, and viewers, thank you so much. Keep watching. Thank you so very much.
Thank you for inviting us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.